Hi everyone. Today what we'll be doing is the Contract Law Unit 3.28. My name's Shazia Khan and today we'll be doing the assignment discussion. But before we go through the assignment discussion, I want to give you a summary of all the learning outcomes we've gone through, which are 7 learning outcomes. So you have an idea of what we need to go through to complete this assignment. So I'll go through each learning outcome quite quickly, so because we've got separate videos for these as well, so that you could go and listen to these later on. But I'll give you a summary and then we'll go into the assignment discussion. So the first learning outcome that we looked at, all these learning outcomes will relate to the assignments, which we'll go through, is learning outcome 1. In learning outcome 1, we looked at the key principles of contract law. So we looked at things like what a contract is between, so it's an agreement between 2 or more parties. And we looked at a legally binding contract. We looked at how contracts are a huge part of everyday life. For example, if we go into a shop, we buy something, we go into a restaurant, we pay for food, employers exchange, a contract to perform their work in exchange for a salary. So there's different elements of everyday life that we use a contract. We also looked at how a contract is made. So the formation of a contract, how it begins with an offer. We've got acceptance, consideration. We looked at what is required for a legally binding contract. So we looked at the 3 elements, which is an agreement, an intention to create legal relations, and consideration, which is in the form of payment. We looked at certainty of terms, and how they're important within a contract and how it's so important to have terms in the contract. We also looked at the basic principles, which I mentioned a little bit earlier as well: offer, acceptance, consideration, contractual intention, form, and the contents of a contract, which is express and implied terms. And what happens towards the end of a contract, so the expiration date, termination, frustration, damages and remedies. We went then to look at 1.2, which we looked at the different classifications of a contract. So we looked at things like an express contract, where the parties state the terms orally or in writing. We then went on to look at implied contracts, which arises actually from mutual agreement. And then we looked at quasi contracts, where there's no offer and acceptance. We then went on to look at contracts on the basis of consideration. We looked at bilateral contract and unilateral contracts, executed contracts and executory contracts. We then went on to look at contracts on the basis of validity. So we looked at a valid contract, a void contract, illegal contracts, voidable contracts, or non-enforceable contracts. We then went on to look at the importance of illegal and voidable contracts. And then we looked at how voidable contracts how they can be legally terminated. That was learning outcome 1. We then went on to learning outcome 2, which was looking at understanding the key elements of a binding contract. And we looked at 2.1 within learning outcome 2, which looked at distinguishing between an offer and an invitation to treat. So we looked at what an offer is, where the client, who's the offerer, is prepared to be contractually bound by a statement of terms, which then in terms become a contract. We looked at offer and acceptance, so the termination of an offer, and then we looked at acceptance, so how a contract becomes binding when it's accepted. We then went on to look at invitation to treat and why that is different from an offer. We looked at the difference between each one with reference to examples and cases. We then went on to look at 2.2, which was to explain the issues regarding the postal rule. We looked at the importance of the postal rule, why it's so important, why there's a need to have the postal rule. We also looked at issues relating to the postal rule. You know, the problem is until an offer or acceptance is actually received or deemed to be received, it can be retracted. We then went on to look at 2.3 within Learning Outcome 2, which was to explain consideration, the rules of consideration and the test of enforceability. We looked at what the basic rule of consideration is and the common definition of consideration. We then went to look at traditionally what consideration is implemented as. We then went on to look at requirements for consideration to be valid. So we looked at the first one was consideration must not be passed. And we looked at cases such as Roscola and Thomas, Eastwood and Kenyon, and R and Clark. We then went to look at another requirement, which was that consideration must move from the promisee, which is the claimant. And we looked at the case of Tweedle and Atkinson, 1861. We looked at another requirement of consideration where it must be legal. And the case in regards to that is the case of Wyatt and Craigliner and Furno, 1933. Another requirement is consideration must be requested. We then went on to look at another requirement, which is consideration must be sufficient. And the leading cases in regards to that is the case of Thomas and Thomas, 1842, and Chappell and Nestle, 1960. And we then went on to look at cases such as Wire and Bloor and Alliance Bank Limited. Another consideration we looked at in regards to consideration must be sufficient. Another case, sorry, was Combe and Combe, 1951. We then went on to look at another requirement for consideration to be valid, and that was the performance of existing duty. And the case we looked at in regards to that was the case of Glassbrook Brothers and Glasmorgan City Council, 1925, and Hartley and Ponsonby. We also looked at cases such as Shadwell and Shadwell, New Zealand Shipping, in regards to contractual duty to a third party. So that was Learning Outcome 2 in regards to understanding the key elements of a binding contract. So looking at offer, invitation to treat, postal rule, and consideration and test for enforceability. We then went on to look at Learning Outcome 3, which is to look at understanding the contractual terms and exclusion clauses. We looked at 3.1 within Learning Outcome 3 to look at analysing the difference between a condition and a warranty, using cases to exemplify the analysis. We looked at what a condition was. So a condition is a term of a contract that goes to the root of the contract. And we looked at the how it could be, what contract would include a condition, and why it's so important to have condition in a contract. We then went on to look at what a warranty is, and how it was less significant than a condition. You know, so we looked at the issue of if a warranty was breached. We looked at comparison chart between a condition and warranty and the difference between them and when it becomes possible. We then went on within Learning Outcome 3 to look at 3.2, which was to explain how terms are implied within contracts. We looked at express and implied terms, how they include the terms which parties explicitly include a contract are known as express terms. And then we looked at implied terms as well. We also looked at an example of a landlord and tenant may agree by way of deposit that the landlord will give a landlord painting, and this was in regards to implied term, and the tenancy agreement may include an express term stating this. And then we looked at the Housing Act, how the law looks at express terms in regard to a contract. We went to look at contract terms implied by statute and contract terms implied by custom, and then contract terms implied by the courts. We then went on with the learning outcome 3 to look at explaining the importance and methods of incorporation. We looked at incorporation of terms and the meaning within English law, and we looked at a notice, contractual and attention of the third party. So we looked at incorporation of terms. We looked at notice first in more detail and looked at the cases of Ollie and Marlborough Court Hotel 1949 in regards to a notice. We then went to look at contractual document and the case of Lestrade and Freygub and Chapelton and Barry Urban District Council. We then went on to look at our attention of other party, and we looked at the case of Parker and South Eastern Railway Company and Thompson and London, Midland and Scottish Railway Company. We then went on to look at learning outcome, we went on to look at the assessment criteria 3.4, which we looked at the importance of construction for interpretation of the contract. We looked at how courts to interpret contracts. We looked at how courts interpret contracts with the reference to a diagram which identified how things like, looking at the natural meaning of the words, contract as a whole, how the contract was performed, pre-contract negotiations. So we looked at that. We looked at the importance of construction in contracts, so the natural meaning against the commercial common sense meaning and how this was important in courts. We looked at badly drafted contracts. We looked at exclusion of pre-negotiation contracts. And we looked at limiting the factual matrix. We looked at also limits of commercial common sense and contract as a whole. We looked at tools of construction and where they're important in the construction in contracts. And that was learning outcome 3. So now we're going to go on to learning outcome 4. In learning outcome 4, we looked at understanding the legal issues of misrepresentation and mistake. So we looked at assessment criteria 4.1 was to distinguish a term of a contract from a misrepresentation. We looked at what misrepresentation is in the form of a contract. It is an untrue statement of fact made by one party to the other, which was intended to induce the latter to enter into a contract. We looked at the remedies for misrepresentation, things like rescission and the effects of rescission within a contract. We looked at damages for fraudulent misrepresentation and for negligent misrepresentation within the Misrepresentation Act 1967. We also looked at remedies for misrepresentation, so for innocent misrepresentation, and we also looked at limiting liability for misrepresentation. We then went on to look at 4.2, which was to differentiate between the different types of misrepresentation. And we looked at the types, which was innocent, fraudulent, and negligent, and went through each type separately to identify the importance of them and how they apply within a situation. We looked at what actually constitutes innocent representation. We then went on to look at fraudulent representation and what constitutes that. We looked at negligent representation, and we looked at leading cases for rescission, such as Khan Universal Finance Company Limited, fraudulent misrepresentation, Doyle and Albee Ironmongers, 1969, negligent misrepresentation, Howard Marine and Dredging Company, 1978, innocent misrepresentation, and we looked at limiting liability for misrepresentation. We then went on to look at 4.3, which was to explain the categories of mistake, common, mutual, and unilateral mistake, and their impacts on a contract. We looked at mistakes in contract law, where it refers to incorrect understanding by one or more parties of the contract. Again, we looked at the types of mistake and misrepresent in contract law, common, mutual, and unilateral. We went through each of the mistakes and what they meant. We looked at cases of common mistake, and referred to cases such as Galloway and Galloway. 1944, and Coutier and Hasty, 1856. We looked at common mistake to the possibility of performing the contract, mistake as to the quality, and cases such as Bell and Lever Brothers Limited. We looked at mutual mistake and how that becomes an element of a contract, and unilateral mistake. Within unilateral mistake, we looked at cases such as Haytog and Collin and Shields, 1939. We also looked at the distinction to unilateral mistake with the contract made into absentees, and we looked at distinction to unilateral mistake with a contract made into precedenters, and referred to the importance of each one within learning outcome 4. We then went on to look at learning outcome 5. And a learning outcome 5 is to understand the legal issue of frustration within contract law, and how a contract can be frustrated. We went on to look at 5.1, which we summarised the different ways in which a contract can be frustrated and provided examples of each. So, we looked at the elements of how a contract can become frustrated from the beginning. When will a contract be frustrated? So, delay, it could be any sort of issues around having to establish an element of frustration. We looked at a frustrated contract and looking at how difficult it can be to establish a frustrated contract. We looked at events leading to a contract being frustrated, things as, the destruction of subject matter. It could be strikes. It could be effects of war, personal services, government intervention. We looked at cases in regards to them, such as Taylor and Caldwell, 1863. We also looked at Condor and Baron Knights, 1966. We looked at the cases of Pioneer Shipping Limited and BTP Dioxide Limited, 1982. We also looked at the case of Krell and Henry, 1903, and Home Bay Steamboat Company and Hutton, 1903. And we looked at cases such as the Metropolitan Water Board and Dick Care, 1918. So this was all in regards to how a contract can be frustrated within learning outcome 5. Then we went on to look at learning outcome 6, which was looking at understanding the legal issues of duress and undue influence. We looked at AC 6.1, which was to explain the concept of duress and undue influence. We looked at how duress and undue influence becomes a part of a contract, and how someone can, force you to sign the will or else, so there's an element of force there within duress. We looked at duress by threat of violence. We looked at duress by threat of violence with an element of leading case of Barton and Armstrong, 1976. We looked at the effect of the threat. So, a case that was really important, leading case for that, Northern Ireland and Lynch, 1975. We looked at duress with reference to economic duress, and looked at the Pour On case, 1980, and lack of practical choice. We then went on to undue influence, unfair, and that is regarded as unfair persuasion. So, it's milder than duress, but it's still a form of duress, undue influence. So, examples we gave of undue influence. So a doctor takes advantage of an ill patient, a child takes advantage of an infirm parent. So that was in regards to duress and undue influence, and we looked at with reference to cases. We then went on to the final learning outcome, which was learning outcome 7. We looked at understanding the legal issue of damages and why that's so important within a contract, and how they are awarded. So if there's a breach of a contract, damages are generally awarded. And the general purpose of an award of damages is to compensate the injured party. So we looked at that. We looked at the general rule to damages. We looked at damages within contract, so non-compensatory damages such as nominal damages, aggravated damages, restitutionary damages, and account for profits. We looked at how damages for breach of contract are subject to principles of remoteness, causation, and mitigation. We looked at each of them elements separately. So we looked at remoteness and what that term meant, causation and mitigation with regards to a contract. So we looked at all the elements in Learning Outcome 7 in regards to damages that are awarded if a contract is breached, and what form of compensation is awarded in regards to damages to the injured party, and how they are awarded and how the courts would award them. So that's all the learning outcomes 1, 2, 3, 4, 5, 6, and 7 in regards to completing this unit. Now we're going to go on to looking at the assignment discussion. So the slides are up here. So the ATHE Level 3 Diploma in Law, Unit 3.28, Contract Law, and it is the assignment discussion now. So the unit aim is to get learners will develop a knowledge and understanding of different aspects of contract law. So as we've looked at each learning outcome, give you a summary of that, it identifies elements that are different elements of contract law, things as offer, contractual agreement, terms, breaches, damages, things like that, mistake, misrepresentation. So we've been through all that. Now we're going to go on to the assignment. So what information needs to go onto the assignment before doing anything? You need to include the following. So you need to include your name on the cover, and your registration number, and the unit level, which in this case is Level 3 Contract Law. And this is really important so that the marker knows whose work it is and whose work they're marking as it comes through Learner Works. You will then have to make sure you have an assignment declaration, which is there to identify that the work that you are submitting, you understand that the definition of plagiarism, and you understand the penalties and collusion, and this work is your work. Okay, so you need to make sure that the work you are submitting is your work and it doesn't belong to anyone else, okay? Because that's really important, and you are acknowledging this by signing the declaration. At the start of the assignment, you need to include the following, which is really important because it's, again, clarity and structure of the assignment. Table of contents. Your font size needs to be 12. 1.5 line spacing. Page numbers need to be inserted. So if you have a contents page, you would refer to the page number. An introduction, and make sure you are putting all the assessment criteria in headings. So if you have a task to do and you have 5 assessment criteria within that, make sure each assessment criteria, so it could be the first one to 1.1, make sure it is within the headings that are on the feedback sheet, not what you want to put in the headings. The wording needs to be the same. So you really need to make sure that the wording is the same and make sure you are clear on that as well. So the learning outcomes, as we've gone through them, I've given you a summary of them, and they are individually done and recorded and on Moodle for you. The first one is to know the key principles of contract law. Secondly, to understand the key elements of a binding contract. Thirdly, to understand contractual terms and exclusion clauses. Fourthly, to understand the legal issues of misrepresentation and mistake. Fifthly, to understand the legal issues of frustration. Sixth learning outcome is to understand the legal issues of duress and undue influence. And the final learning outcome, number 7, is to understand the legal issue of damages. So you need to go through each learning outcome. They're on Moodle, recorded separately, so it's easier for you to understand. Now going on to the assignment and what is expected of you when completing this assignment. So you have just finished your course and have been working in a small firm, family-run business for 6 months on a temporary basis. You love your work, but you can see that the family has no idea about their legal obligations. They do not appear to understand contract law, and you decide to produce some information for them. You intend to collate your information as a formal report and give it to the key members of the staff so that it will impress your managers and hopefully lead to a permanent job for you. In this, the study skills used, developed and assessed through this assignment are as follows. You need to be able to be a critical thinker, okay? You need to plan and organise, and that's really important within any assignment, within any form of academic studies. You need to be a good planner and you need to be organised, because when you are not organised, for example, if you're doing an assignment on English legal process and you're doing an assignment on contract law, you need to make sure you are planning when you do the contract law one and when you do the English legal system one, rather than doing them both together, because it becomes confusing. So plan, organise, it's really important. Gathering information, note-taking and summarising, and that is really, again, important, so you don't confuse the different modules that you are doing or the different units you are doing. Gather your information, note-take anything you think is important, and summarise your notes, and so it makes it easy for you to understand. And the next element is analysis. You need to be making sure that you are analysing the questions, the tasks you are being asked. And, you are referring back to the question and what they're asking you. Written skills is really important. Academically, you need to be writing a good piece of work. You need to be able to write an academic piece of work, and you need to have good written skills. Another one is academic skills, which is really important in regards to that, and application of IT skills. And again, IT skills is really important when you're submitting your work in the form of Microsoft Microsoft. You need to be able to type it and have the basic academic skills, PowerPoints, things like that, whatever you are expected to do. So these are the study skills that will be used, developed throughout doing the assignment. So section 1 of the assignment, the principles of contract law and the key elements of a binding contract. So you must start with the basics. In the first part of your report, you should include number 1, so the first bit of it, inform them about contract law, outline the key principles, the requirements of a contract, and the moral, social, political, and commercial factors that affect upon contract law. Use cases to exemplify your work. Make sure that is your heading as well, okay? Make sure you are doing each element as requested in that, okay? That's your assessment criteria within the assignment. You need to secondly, so that would be your heading. That all would be one of your headings, okay? Secondly, this is another heading. You need to describe the different classifications of contract. Then you need to also make sure that the key people understand the key elements of a binding contract by distinguishing between an offer and an invitation to treat. And that is your heading. And then you will write under the heading. So to make sure that the person marking it is identifying that you've completed each assessment criteria. You need to look at explaining the issues regarding the postal vote, which is another bit of it, another heading. And then you need to also look at explaining consideration, the rules of consideration, and the test of enforceability with regards to that. And each of them that we've gone through, so 1, 2, 3, 4, 5, you need to be having as headings, okay? So if you want to do, these are all for pass criteria, you need to make sure you've got headings and you are writing under the headings. Now, to get extra marks for the extension activities to gain a merit for section 1, you need to also, and put this as a heading and put it's a merit criteria, you need to explain the methods of acceptance and when they will be effective, and you must provide examples to illustrate your answers. So when they ask you for examples or case law, you must be providing examples, plus you must be providing case law as well to gain these extension activities. Now, to gain a distinction, so if you want to work on further, you have to complete the merit and the distinction ones. In the distinction ones, you've got two parts. The first criteria is to analyse key theories of contract law, and then right under that, what the key theories are. And then the second part of the distinction element is to analyse the issues organisations must take into account when using instantaneous methods of communication in respect of contracts. Now, these activities are the extension activities, and this is where you would gain the merit or the distinction. So if you want to gain the merit or distinction, you would need to either complete them to gain the merit and that to gain the distinction. Okay, so these are to complete the elements of a merit or distinction, and this is for section 1. Learning outcome covers for section 1, so it would be learning outcome 1, and the assessment criteria is 1.1 and 1.2, and then learning outcome 2 and it would be assessment criteria 2.1, 2.2, and 2.3. And this would complete section 1. So you need to make sure, if you want to do the extension activities, you would complete the extension activities for merit and distinction, and make sure you are looking at learning outcome 1 and 2 for section 1. Section 2 now, okay? This is on contractual terms and exclusion clauses. There are some staff in the company who need more detailed information on contractual terms and exclusion clauses. So to help them, you must produce a report to include a section in which you can. So these are the 4 elements you've got to look at in section 2 for the pass criteria. So the first one you're looking at is that one, and have that as a heading, okay? So it's clear that you've completed that assessment criteria. Analyze the difference between a condition and a warranty using cases to exemplify the analysis. Then the second one is to look at explaining how terms are implied within a contract, and then right within that. Then the third assessment criteria is to explain the importance and methods of incorporation, and then right under that. And then the fourth part of section 2 is to look at assessing the importance of construction for interpretation of a contract. So these need to be covered in regards to your element of section 2, and each one needs to be covered individually with the heading and then the work under that. The extension activity, so to gain a merit, you must also do this as an extra activity, distinguish between a term and a representation, and that would gain the merit for you that you want, okay? That is your own choice if you do the extension activities or not. Okay, learning outcomes covered for this section, which is section 2, is learning outcome 3, assessment criteria 3.1, 3.2, 3.3, and 3.4. And this will cover section 2 of this assignment. Okay, now moving on to section 3, further legal issues. So to bring this organisation completely up to date and up to speed, you really want them to understand the legal issues of misrepresentation and mistake, frustration, duress, and undue influence, and damages. So you need to add a further section to your report. And for this, you need to look at these elements. So firstly, you need to distinguish a term of a contract from a misrepresentation. And that is the heading, and you need to write under that where you will distinguish a term of contract from misrepresentation. Secondly, you need to differentiate between the different types of misrepresentation. So negligent, fraudulent, these are the ones that you need to look at in regards to that. And then thirdly, you need to look at explaining the categories of mistake, which common, mutual, unilateral, and their impacts on contracts. So you need to look at that within this part of it. So 3 parts there. You also need to look at summarizing the different ways in which a contract can be frustrated, providing examples of each. So you need to be able to have that as a heading, and then right under that, all of the work needs to have its each heading for assessment criteria, and then you write your work under there. You need to also explain the concept of duress and undue influence, and that is another heading. You need to look at the 6th element, which is explain the concept of remoteness and measurement of damages. So you need all these as headings to write about each one. Right, to look at the extension activities for this. So to gain a merit, you must also look at explaining what is meant by actionable misrepresentation. You would have that as a heading and you would write under there and identify clearly that this is a merit activity. You would also, another part of the merit activity, which you need to complete both elements to look at the merit grade, is to explain the impact of mistake. So common, mutual and unilateral on a contract. And these need to be both completed to complete the merit grade and the extension activity. So they both need to be a heading and you need to write under each one. And to get a distinction for section 3, this is for the distinction element of section 3, you need to look at firstly analysing the remedies for misrepresentation, and that would be your heading. You would then, there's 3 parts to gain the assessment criteria for distinction. Then you would need to look at analysing the impact of duress and undue influence can have on a contract using examples to exemplify the analysis. So case law examples, other examples outside in regards to duress and undue influence, how someone, a child could, threaten a parent, as we mentioned, an employer could threaten the worker, a husband could threaten the wife under undue influence and duress. So you need to make sure you are using this in regards to exemplifying this with examples, because that's what it's asked for. And then the third part to gain the distinction is to explain the impact of the remoteness and measurement of damages using examples to exemplify the explanation. So each of these needs to be done for each task. So within section 1, 2, and 3, you need to complete all the elements of that in regards to the assessment criteria. So each point you need to make sure it's clear with a heading, and then you write under the heading. Okay, you also need to make sure that you are using Harvard reference system throughout and also referencing your work. And if you're using cases, make sure you are using where they've asked you for case examples or any other examples, make sure you are using them. Avoid, it needs to be an academic piece of work, it needs to flow, avoid using bullet points, okay, to complete this assignment. So section 1 would be clear where it's covering all the elements. If you want to cover distinctions and merits within each section, you can do that. It's up to you. The decision is yours. You would need to complete all the past ones and then complete the merit distinction ones if you want to. Okay, that is all entirely your own decision. Make sure, again, when you are completing the extension activities for a merit and a distinction, that you've made it clear that you've completed them. So the learning outcomes covered for section 3 of the assignment is learning outcome 4, assessment criteria 4.1, 4.2, and 4.3. Learning outcome 5, assessment criteria 5.1. Learning outcome 6, assessment criteria 6.1. Learning outcome 7, assessment criteria 7.1. And where you would find information for section 1. So this is just an example. So I'm going to go through a part of each section and pick out a question, which I've done, and then show you where you can find that question and what learning outcome and what slides it's on. So we look at example 1 in section 1 and where to find it on the slides and which learning outcome covers this. So the first one I took out was explain the issues regarding postal rule. And this was just an example, but also it will help you and guide you. Where you would find this for task, you would go on to learning outcome 2, and it is the slides learning outcome 2, pages 8 to 11. We'll find the answer to explain issues around the postal rule. So that would cover you as an example to look at pages 8 to 11 for learning outcome 2 to cover the element of the postal rule. Secondly, the second section I've looked at where you would find information on this task in regards to the task which I picked out was to analyse the difference between a condition and a warranty using cases to exemplify the analysis. And you would find this on Learning Outcome 3. Okay, so you would look at Learning Outcome 3 and you will look at pages 3 to 6, which looks at analysing the difference between a condition and a warranty and using case examples to exemplify this. So you would need to look at case law in regards to it, look at the difference between both and look at why it's so important in regards to the difference between a condition and a warranty. For section 3, I picked out an example from there, which was to differentiate between the different types of misrepresentation. And to find this, you would go to Learning Outcome 4, and you would look at pages 8 to 15, which looked at the different types of misrepresentation and why they are so important, okay? And looked at each one individually and look at why they constitute misrepresentation. So you'd look at fraudulent, innocent, and negligent. You also would look at things like cases in regards to innocent misrepresentation, which could be things like the Whittington and Seal case, 1900. For fraudulent misrepresentation, Doyle and Olby, Ironmongers Limited, 1969. And then for negligent misrepresentation, the case of Howard Marine and Dredging Company Limited, v. Ogden and Sons Limited, 1978. So you need to be looking at the different types of misrepresentation with reference to cases to identify. So these are the examples that I've given you for section 1, section 2, and section 3 of the assignment, and it'll give you an idea on what pages they're on, and you will do the same for every other one, okay? So it's clear for you. At the end of the assignment, make sure you do a conclusion. Make sure you reference your list and your bibliography. So it's so important to have a reference list or a bibliography to identify where you've got your resources from and to identify what sources you've used. I've provided you with an example of each of the section of the assignment and I identified where you can find the information to complete them. You will need to do that for all the sections as I've just mentioned, and also you would need to do additional reading to evaluate and support your answers. And additional reading and sources would be available on Moodle for you. Referencing all 3 sections of the assignment, you should use and cite a range of case law, academic sources and reliable sources, and the sources need to be reliable in regards to answering each bit of the assessment criteria. You need a comprehensive Harvard referencing style. Reference list must be included at the end of your work. Learners must show that you understand the subject area and you have a knowledge of the subject area, because it's so important that when you're reading something, you're able to understand what you are writing about. You must provide references to relevant case law and or legislation wherever appropriate. You must be able to answer, support your answers and show evidence of wider reading appropriately. So you need to make sure that it's clear that you've read this area, that you are talking about another area. You're able to identify that you have used the sources, the relevant academic sources. So a summary, make sure you start with an introduction because it identifies that you're able to understand what you're doing at the start, and then make sure you end with a conclusion. Make sure you are using, as I mentioned again, Harvard referencing system for referencing. You can refer to online sites that may help, such as Neil's Toolbox, which is really good in regards to helping you reference your work. It helps you reference journals, websites, books. It could be any academic sources that will help you reference. If you are using diagrams, if it asks you for comparison and you are using diagrams, make sure you reference them accordingly. so that it's clear that you've taken this from here, or it's clear where you've taken the sources from. Again, make sure you have a bibliography, reference list, and it's in alphabetical order. Make sure you are referencing throughout your work as well, so it would be the author and then the year. Try to use more examples when explaining certain concepts. For example, when looking at theories, or when looking at the different types of misrepresentation, when looking at an offer, what an offer is, what acceptance is. Make sure you have a case in there that identifies, it might be a principle, it might be the first case that identified what an offer was, what acceptance was. So you need to be able to support your answer with case law, because it's so important. And look at giving examples as well, where a contract becomes void, or where there's an element of a contract becoming frustrated, or where there's undue influence, or any sorts of elements like that. So you need to make sure they're supported by your sources, like and examples. Okay, make sure you are using the assessment criteria as a heading for each part of the task. If you're looking at task 1 and look at AC 1.1, each part of the task should be done as a heading and answered under that heading. Rather than just putting a heading saying formation of a contract, you need to make it clear what you are being asked to do and what you are answering, so it's clear, and it's the same as the feedback sheet, and it's the same as your assessment criteria, rather than just putting a heading in that you want to put in. So make sure you are looking at the assessment criteria carefully. You need to be referring to the indicative content all the time and checking your word count. So some useful tips. Read the task carefully. Read the tasks. Keep reading the tasks. It's really important. And focus on what it's asking you. Focus on the detail. Focus on what you are being asked, rather than what you're going to what you're going to answer yourself. So make sure you are focusing on that. Command words. So broadly, just as a guidance, I suggest that for action, command words, you can cover the task by writing them. So explain, define, describe, 70 to 100 words. Assess, examine, clarify, analyze, 100 to 125 words. Compare, contrast, critically, and then evaluate, 150 to 200 words. Harvard referencing, again, going back to importance of references, we've reiterated this through the assignment. Referencing needs to be in Harvard system. So, for example, the author and date of style. For example, Slack, Johnston, Brandon Jones, 2011, in the text. So in the assignment, you would write that. Then you would write the full citation towards the end. In references, it will come as shown. So in the end, you would write the full, where you've got the book from, the publisher, the year. Word limits, make sure you stick into the word limits. Give proper headings and subheadings. As I've said, the subheadings should be the assessment criteria and the section of each one, whatever you're doing. So if you're doing the past ones, make sure you are doing all the past ones as a heading and then writing under each one. If you're doing the extension activities for merit and distinction, make sure you are writing under each one what you are doing, and clarify that it is the merit or distinction one. The word limit's 3,500 plus 10% leeway, and plagiarism or tolerance similarity must be below 20%. And that is so important that because you are declaring at the start, that declaration that this work is your work, so your plagiarism needs to be very low. Just some final plenaries. You need to make sure you are not copying and pasting work, as it's plagiarism and would lead to academic misconduct. So make sure you are not taking sources out from the internet but not referencing. Make sure you write things in your own word and paraphrase things. Make sure, again, and I go back to this all the time, reference your work. Make sure your work is all referenced, and make sure you check your grammar and spelling, and avoid using American style words. For example, things like, if you're writing about analyzing it, instead of the Z, you need to insert the S, because the computer is an American style. So make sure you check your grammar and spelling, and also again avoid bullet points, and I will reiterate this. Make sure you refer to ebooks and journals on Moodle for this unit. Any sort of additional reading you've got on Moodle, please refer to that. There will be additional sources. There may be additional cases that you need to refer to. Make sure you're referring to that for any sort of additional resources. Your each of the learning outcomes is recorded, so that if you need to go on and listen to all that, it's all recorded. And this assignment discussion is also recorded for you to go on if you want to refer back to something. If you have any questions or any sort of queries, kindly email again learnerwork@ukvarsity.co.uk. Submission of the assignment must be done on learnerwork@ukvarsity.co.uk. And the assignment submission is after 2 weeks of completion of the units and its delivery. So now that the contract law unit has been completed, you have 2 weeks to submit the assignment and complete the assignment. Make sure you are looking at all the learning outcomes. I reiterate this throughout the assignment. Make sure you're looking at your structure and flow of the assignment. Make sure it's an academic piece of work rather than putting bullet points in it. And make sure that you are looking at your referencing and also looking at your grammar, punctuation, and also make sure you are not cutting and pasting things. So we've finished the assignment discussion. If you have any questions in regards to the assignment, please email learnerwork@ukvarsity.co.uk. Thank you for attending today's session, and this is the last session. Thank you.